Hello, this is Brian Jackson, and I'm an attorney here in Salt Lake City, Utah. I focus on employment law and help a lot of employees with some of their employment questions they have and work out their legal issues. And I guess I decided to put this podcast together with a lot of questions that I've been seeing from potential clients and individuals they have regarding employment rights. A lot of people, I get emails or voicemails, messages on my website, and a lot of the questions is, what are my employment rights? And here in Utah, it's a little bit interesting with the at-will doctrine that they have. So first of all, I think it's important to know what the at-will doctrine is and then how it applies to employees' rights. And I think there's kind of some misunderstanding on the employer's side that can get them in a lot of trouble in understanding those rights. But essentially, at will means that you can terminate an employee, or an employee can terminate their relationship with the company at any time for any reason. And the policy and reason behind the at-will doctrine is essentially because an employee can terminate for whatever reason, the employer can also terminate for whatever reason, and what the consideration is according to courts, because essentially under most contracts you have to have consideration, meaning if I give somebody a penny and say I'll exchange whatever you have for a penny, there's consideration. There's an exchange of something, promises, but in some contracts there's no consideration and or reason for breach. And here it's interesting because under the policy, it's you can terminate an individual for any reason at any time. And the policy and its issues is that an employer really has the high ground when it comes to terminating employees. Usually an employee won't want to be terminated from their employment, and usually there's provisions where an employee has to give a certain amount of time of notice before leaving their employment, and there's really low amount of reasons why an employee would leave a certain company compared to the reasons why an employee could terminate an employee. And so there's really not fair ground on the justifiable reasons for the at-will doctrine. But that's what it is here in Utah, and essentially, an employee or employer can terminate the business transaction at any time for whatever reason. And I guess the downside to that is that, number one, it doesn't give the employee a lot of protection to their job. So it makes it so they're sitting on pins and needles, and they pretty much have to jump through a lot of hoops that the employer gives them, and sometimes have to deal with an unreasonable employer in fear that they might be terminated for whatever reason. And so that creates a lot of problems, and it kind of gives companies an incentive to not treat their employees with respect, or regard them with the importance they have with the job they're doing, the money that they're helping bring into the company, the services that they're providing. and kind of makes it look like those individuals are expendables. And it's scary too, because a lot of individuals that contact me, they've been working with their company for 20, 15 years. And so it's kind of been, it's kind of an integral aspect of their life that they've implemented working with the company, and they've put a lot into the company. And then if for whatever reason management changes, or there's a disagreement, and there's some kind of personal bias and they terminate, it just seems pretty unfair on how the at-will doctrine favors an employee at that point. But that's kind of where we are with employment law and the at-will doctrine. There are some caveats, though, to the at-will doctrine that I want to talk about. So, and essentially, the main big thing is discrimination. If for whatever reason you can prove that you were terminated, even though you were at will, based off your religion, based off your race, based off your gender, based off you being pregnant, requesting maternity leave, based off any other kind of protected class disability, then you may have a discrimination claim. And there you can claim that you were wrongfully terminated by the company based off discrimination. Those cases are tricky. You have to jump through some hoops. You have to go through an administrative process with the EEOC, and they conduct an investigation. And the problem there is that right now there was an audit about a year or so ago with the labor division and the discrimination division, and they found that there's a lower amount of findings of discrimination in the state of Utah compared to the federal level and compared to other states. And there's also an issue of the investigations themselves, the findings, the conclusions, and then also the actual manpower that there is for those investigations to be conducted. They're supposed to be conducted within 180 days, but I don't know if that ever happens, or it rarely happens, and usually the investigation extends well beyond that. And the issue there is with that is if an individual is terminated and they're trying to get some kind of recourse from the company for wrongful termination, and they're out of the job and they can't work, they have to find a way to try and support themselves, with also hopes that maybe they'll get some kind of compensation for the company. And essentially, I tell most of my clients not to bank on that, not to get some kind of compensation. A lot ask, well, will it hurt my case if I get another job? And I say, the case doesn't matter. You got to eat. And so if you can find another job, it's good to get another job. If they do make a finding of wrongful termination, you have to mitigate your damages, meaning that if you get a job and it pays a certain amount, the damages you receive will be subtracted for lost wages and benefits. So that's something to think about as well in bringing a wrongful termination action. Is if you get another job and it pays more, then